Hello, my name is Joanna. I'm from Family Law Cafe, and today the big billing is I'm going to be talking to Samita Martov-Sheikh, and the big reveal is that unfortunately one of her children has been taken to hospital completely unexpectedly. Really concerned and hope everything's fine. So just had a message 10 minutes ago that she's at hospital and can't join me. So Samita, hope everything is okay. We will get her back hopefully in a couple of weeks. Obviously, hope everything works out. I did put in a call to my lovely buddy, another barrister buddy, but obviously only had 10 minutes to try and sort this out. So it's just me, and I thought what I would talk about today is being a barrister, what a barrister can add to your family case, when you might want to use one, when a barrister is instructed by a solicitor, so it's a solicitor instruction, and what the barrister does then, what a direct access barrister can do in your family case, and sort of things that you might have some questions about how a barrister approaches things. And obviously welcome your questions, and if you want to put them in the comments, put them in the comments below. I always find when I'm wearing my glasses, it's not ideal. It's better when I'm wearing my lenses for these lives, because I then have to sort of peer. I have bifocals, so it's not ideal. I know that you can get glasses that are good for screens, and I obviously need those. So I'm not ignoring you if you put a comment. If I peer, it's because I'm trying to read it. So thank you for all those that are joining. Give me some love if you can. That always helps the analytics, whatever they're called, or that that Instagram look at. Apparently, if people like what you're doing, then they might show it to more people. So please give me love. So yes, I'm a barrister. Was going to be speaking to another barrister today, but we will do that. Won't be today. And I'm going to talk about what family law barristers do. So as you probably know, or may not know, the lawyer profession is split into two sides. You have solicitors and you have barristers. The training is different. The early stages are usually the same. You either get a degree, it can be a law degree, it doesn't have to be a law degree, your initial degree, and then you have different training to be a solicitor, and if you want to be a barrister, you undertake bar finals, and then you do a pupillage, and getting into chambers is always quite difficult, as at that stage quite a lot of barristers do drop out because they struggle to get into chambers initially. I qualified as a barrister when I didn't come straight to the bar. I did some other things, and I qualified at age 28. I always wanted to be a barrister. It's something I decided I wanted to do when I was about 14, but I was doing some different things. And to be honest, I felt just too young. I did a law degree, but I worked in publishing and journalism, just little bits. I'm not saying I was high up or anything. I was doing a lot of sport. And so I'm travelling, kept having sort of, different gap years or doing different things. I always intended to come to the bar, but I felt that some life experience was a good thing. So I didn't come straight to the bar. Some people do, and they can get through really easily, 23, 24. I came to the bar and I got a pupillage, James Van Goddard QC, a criminal set. I didn't actually know about different types of barrister because my parents were not lawyers. They weren't highly educated. Not that they weren't clever and amazing and capable and successful. But my father didn't have any education, I don't think, after about 13. I think he left school about 13. My mother left school at about 15. As she told me, she matriculated, but her family didn't have the money. It wasn't possible to go to university because they didn't have the funds. She had qualified to go. So they were successful, but I suppose successful working class. And so it wasn't, the obvious thing that I would become a barrister, and I just saw it on TV. I watched a programme called Crown Court, and there were barristers there, and there were women asking questions. So I thought this is great. I was good at English at school. My mother put me into drama school. I was terrible actress. But I had that idea that it was good to I like writing. Was always writing plays at school with my friend Julia, and we'd get all the kids, acting our plays at the end of the every week actually. So it was all writing stuff. She's a journalist now, and seemed to me putting acting, writing together, being a barrister, and obviously seeing it on TV, that was the thing to do. So I got into a criminal set, and it was headed by a woman, so that was good. She was fantastic. Anne Goddard became the Recorder of London, amazing barrister, always took the time out for me, coming back from magistrates court, doing my trials and everything I did. So I got a great training. Again, because I didn't really know anything about the bar, I'd imagined barristers defending people. That was always my big thing, that I would defend people from injustice, passionate about social justice, and it was actually a prosecution set. So, as I started to, get through my pupillage, a very busy pupillage, I was at court all the time, I started prosecuting as well. Actually, which is, a big learning experience. You're a good defence advocate if you can prosecute as well. So I was at that set. At the time I was doing loads of sports, so I became quite successful during that time, and so I actually left rather than pursuing getting a tenancy as a barrister. I left and I went to teach barristers, so I did that for 2 or 3 years at the Inns of Court School of Law. I was really young, I'd only just qualified myself, and then I was teaching other barristers what to do, so that's a good way of learning, is teaching, of course. I then came back, and by then I'd sort of sussed out that crime wasn't the only thing that barristers did, and I had done a bit of civil work, and I'd been told I was doing a bit of personal injury work, because criminal barristers hang about the courts a lot of time, and I was told, look, try and have another string to your bow. So I was doing personal injury work, and then I went to do civil pupillage. I did a mixture of things like insolvency and all sorts of weird things when you're in an insolvency court, and it's a big bear pig and people shouting and it's crazy. Before masters, civil cases, I also did family law. So then I was doing a mixture of family and crime. I think it was such a fantastic grounding that I did that for 8 years, because a key thing in family law is you have to analyse facts, and most of the time you're not cross-examining. But on the occasions that you do need to do that, it's good to have it in your arsenal that you do know how to cross-examine someone and just cut through what frankly might be, a nonsense story. Surprise, surprise, people don't always give a true account of things. So I started doing that, and then I was married by then, I had children. Now, just to say, the demands of the bar, they're really quite unusual. You could, with a solicitor instruction, you probably would get your papers the night before, really depended, on your seniority, especially when you're a junior. You might pick up cases that other barristers in your chambers can't do. So you're picking up work and just go straight in, analyse the papers. So barristers are really well trained at analysing things at speed and maybe getting 1,000 pages of documents and just getting down to the real issues in the case. So that's our particular skill. And then, we might go on and do a completely different case the next day, and that's completely out of our minds. So that's kind of how our brains work, for better or worse. Whereas solicitors, I think, are better trained, or they train in really having, perhaps seeing all of the detail and a bigger view of things, whereas barristers tend to focus and zone in on what needs to be decided now and presenting that. So there is a real advantage to using both if you can afford it, because you're really getting the Rolls-Royce service, and if they work really well together. But what I will say, as a barrister, you get your papers quite late quite often. But some people would say it's certainly a disadvantage to your social life, and everybody else that lives with these is completely selfish. It's pretty much, when you're at the junior bar, certainly the only night that I know that or I wouldn't have an obligation more. It might be just Saturday night, because I might be going to court on Saturdays as well. So, and then Sunday you might be starting the whole thing again, because you have the case on the Monday, and you've got to prepare for it. And you can't really hold too much in your mind too early. So, working in the evenings and, is part of what you do. So that's what a barrister does, and obviously in court it's assimilating facts, and there can be it's quite fluid, different things happen. Now, what I would say about family law, when I moved into doing more of family law, is there's much more fluidity about evidence, because there's no hearsay rule. Hearsay is when someone else is reporting what someone else said, so the rule is in criminal law and civil law, unless there's an exception, is that you just give evidence about what you've seen or heard. You don't give evidence about what someone else has seen or heard. Now, in family law, that's just completely out the window. And of course, that a lot of the evidence is someone saying, well, this was reported to me, or obviously particularly in a CAFCAS report is they're giving opinion evidence as well. So the rules of evidence, and I used to teach evidence to barristers, so I was quite sort of well drilled in this. The rules of evidence come pretty much out of the window, and there is a little bit of a feeling of anything goes, because people always fall back on, and they're putting things late, but it's in the best interest of the child that you read this document, So as a barrister, and trying to make sure that you've honed all your arguments, then something else will come in late, or someone will put in an extra statement. You do need to keep dealing with these new things that happen. There's a lot more freedom in the sense of the way the evidence is presented, because the other big thing is the court isn't looking at it as a adversarial process in the way that a criminal case would be dealt with set rules and set ways of doing things. It's semi-inquisitorial, finding the right answer, and semi-adversarial. So it's a hybrid of those two things. So by adversarial, that would be one person giving evidence and cross-examination. Inquisitorial is a court searching for the right answer to sort out perhaps how often a child should spend time with another party, etc., etc. So it's a different species of work for a barrister, and it is specialised. Now, one of the things I think is interesting, just use the word interesting, is I remember and did a lot of legal aid work, public funding work, and that was before the government changed the scope. So since I think it was 2008, they changed the scope of public funding and just took out lots of areas of family law. And that meant the rise of people having to deal with cases themselves. Now, lots of people didn't get public funding, so I'm not saying that necessarily it should be brought back, but public funding is very limited now. It's limited to where there's been domestic abuse. And there's definitely been a change in the tenor of cases and the cases that we do since those changes were made. And sadly, because people represent themselves, and you might have two sides representing themselves, often the judge or the tribunal, it could be magistrates, they shouldn't really be getting into the arena of dealing with how the case is presented, but they have to do that, because of course you can't leave a situation in which vital facts are not decided by the court. So the research shows that cases take 7 times as long as when there's a lawyer, because as lawyers, when we went to court, often we would settle cases even at the court door, and it wouldn't be a bad result, because we would both know all our arguments, what there was to be said, what the outcome was likely to be, and we were able to negotiate on behalf of our clients, and generally people were pretty happy. And I know from statistics that the cases that come back to court after a final hearing, at 1/3 of cases. Now that to me seems completely wrong. That to me shows that cases are not dealt with as well as they used to be, because that proportion of cases that come back to court has gone up. And that could mean, of course, that they're coming back to court because one of the parties isn't obeying the order, or one of the parties isn't happy with the order. So I do think that things have changed a lot, and it used to be very unusual that we'd go to court and have a litigant in person on the other side, whereas now that's a standard situation, that if you are the only lawyer in the case, then you've got to present it differently, because you've got to present it properly and in the best and strongest way for your own client, but you're also an officer of the court. So if there is assistance that is needed to the opponent, then you need to do that. And so you're wearing two hats. You're being the lawyer for your own client, and you're also being an officer of the court and making sure that it all runs as it should do. And often the judge will ask you to present the case, even if you're acting for the respondent, because you can get straight to the issues and present it. And that's really tricky, because you're in a situation then as a barrister in which you are being briefed by your own party, and legitimately they say, well, yes, but you're giving all that assistance to the other side and helping the court. But we do have to do that because that is our duty. We are officers of the court. So being a family law barrister is a great privilege. I honestly couldn't imagine doing anything more fulfilling and worthwhile. It is very stressful, and it is really important not to let it get through your professional veneer, because I'm always passionate about anything I do and any work I do. I wouldn't do it otherwise. But I never imagine that I know better than my own client, or I know better than the court. I am there to take my client's instructions and present them in the best possible way. I will always give the advice that I can give. And of course, the more you have done this, hopefully the better your advice is. But sometimes I do find myself saying, unfortunately, if there is a CAFCAS report, it's going to take 17 weeks. If these allegations are made, the court must treat them as true until there is the fact-finding. So there's lots of things that you feel you just wish wasn't the case, and you are the messenger, but I can't change the system. I can only work within it, and that's what we do as barristers to the best of our ability. One thing that I think is of interest, because the scope of public funding was reduced, so far less cases get public funding, my experience is that there are far less junior barristers around, and just less barristers, because of course a lot of barristers did that work, and that was their way of getting experience and learning and getting funded. And so there are just fewer barristers around, and I think it's hard on the public when you're looking for a decently priced barrister that the fees are very high, and that is because the people that are available to you are people of usually great experience and probably a little bit older, and you don't have those junior barristers. That is, the rationale for me setting up Family Law Cafe was to try and to present an alternative, because I knew I couldn't make public funding come back, and there's lots of faults about public funding. It wasn't the universal panacea that people say, as far as I'm concerned. There were lots of cases where I just thought, I don't even think this would be in court if there wasn't public funding. So sometimes I can see that it shouldn't have been there for every case. However, I do think it's extremely tough for people who may not be the person holding the purse strings. So, for example, it used to be that you get public funding in financial remedy cases, but you get effectively a loan and you would have to pay it back. They could have reformed that system and made it more effective. It used to be the case that then you could if you purchased a property, you would put it on the property. So the government didn't get that money back for, maybe 30, 40 years for forever. So I'm sure that they could have reformed that and helped more people have public funding in financial remedy, because if you're the party that doesn't have any income, it's not straightforward to prosecute your case. And in financial remedy, I really think you need a lawyer. So these are my kind of random-ish thoughts about being a barrister. I did have with me my wonderful wig tin, Miss Joanna Torch. Great privilege to have your wig tin, and you keep in it your lovely wig, which, you know, obviously I'd wear when I did my crime. And you have what's called a collarette, which is a little kind of thing that you put under your suit if you're a woman. You know, rather than having to wear the whole shirt, although you can wear it, you can wear the shirt with the collar and cuffs, and then the lovely gown, which is here. We don't wear these in family cases unless there's very limited times when you need them. So if you're up for, they keep changing it. I remember once I was doing an appeal before a High Court judge. I had to go up to Nottingham, and I well remember, oh no, I didn't bring my robes. You know, I need them going before this High Court judge. And my opponent said, I forgot my robes too, because you're so used to not having them. And we just thought, he'll be nice, and you know, in that usual way, sort of say, you know, it's fine, you know, that we didn't. And he was not fine. And we went in, and neither of us had our robes, and we sent a message in through the usher saying, we're terribly sorry, you know, that craven way. And I just remember the judge absolutely offended by the fact that we weren't robed for this appeal. A family law appeal, when we should have been, but it was really lucky that my opponent didn't have her robes either, so we were both as bad as each other in the eyes of the judge. And then just lastly then to talk about you know, relationships between barristers. We are on different sides in a case. I actually think it's helpful if we as barristers do not get overly emotionally involved and invested in our clients' cases too much, to the extent that we sort of assume those roles. I think we have to remember and take a step back and be as courteous and polite to the other party, because they have their point of view, they are doing their job, and I don't think it helps to escalate tensions if the barristers start getting really difficult with each other. So it is something that's different, I've noticed, in family law. When I did crime, because I guess we were dealing with, you know, perhaps really quite, you know, it could be really unpleasant things, but we're just doing that job. We were adversarial, every point was taken. But, you know, we're in our role as barristers. So there was a camaraderie, there was, you know, people, it was actually quite enjoyable. It's a kind of weird thing to say, and more light-hearted. Family law is incredibly serious, and it can get really tense and difficult, but we are there to try to get to a reasonable outcome that is fair. Of course, we keep the interest of the child absolutely top, but we remember that it is for the court to decide, and we are there as your representative. So that's my whiz through. Last, I have a very quick chat about what the difference is if we're instructed by a solicitor and direct access, or it's called public access now. So if we're instructed by a solicitor, we are a referral profession, so that often people will go to a solicitor who would deal with their case, may never come to a barrister. It generally comes to a barrister if it's going to court, or if there's, you know, a point of specialism that we need to research, might have a conference and give advice. And so we would then get our brief, the papers we sent by the solicitor. There would probably be a conference for the hearing, and we would do the hearing. And then we might come in to the case and go out of it again. So we're just doing part of the case. The difference with public access is you as a member of the public would come to us directly, and I'm very experienced in that, because I worked within solicitors' offices as well. Whilst I was a barrister, I was an employed barrister for 9 years in solicitors' offices, as well as being a member of chambers at different times. So I feel very relaxed dealing with the public directly. And I enjoy that, because I just enjoy having involvement in the whole preparation. So if you come to a public access barrister, you just set out everything you want the barrister to do. You come to an agreement about what the barrister will do and what you will do yourself, and it can reduce your costs, and you have the barrister often at an earlier stage, and you get that direct instruction. Now, some barristers don't like dealing with the public directly. They're used to the referral and they're more comfortable with that, and that's just how they are. Other barristers like to deal with the public directly. I personally do, but I always set my parameters really clearly. Whatever's in the letter that we've agreed, that's what I'll do, and I won't do anything more than that. And I'll keep it really, really tight, because otherwise there's a drift, and you will be doing some of the work yourself, and I will be doing agreed work. Family Law Cafe, what we do is, because I've got a lot of experience in public access, I can recognise the cases that probably work really well as public access, and the cases where it's better to have a solicitor, so we have a network of both. And I look at all the cases, because I've been doing it for 32 years, kind of know where a case is going from the beginning, and then we get you what you need, and we give you the support, and we have the online portal. And because I really like papers to be absolutely in order, then you use that portal to keep everything completely straight. Okay, not surprisingly, I've managed to just talk away, as barristers love to do. There's a sort of joke where the judge will always say, how long will you be, Miss Toch? And it will be, I'll be 10 minutes, and you can just double it if it's a lawyer talking. So I hope that's been helpful. I'm sorry we didn't have Samita. I hope everything's fine with her. I'm sure it is, and we will get her back. Anyone that's got any messages, don't forget you can send a direct message and we'll get one back to you. And if there's anything particular you want us to cover on these tea time lives, let us know. I think the next one we have a lovely solicitor that we work with who's going to be on here. Keep my fingers crossed that will go fine, and thank you all for listening. Bye bye.